Court records are meant to show how justice is delivered, but not every decision is spoken aloud. Some outcomes are shaped by discretion and delay. Others are shaped by procedure, once discretion is no longer needed. These are those cases. This is what happened before the gavel fell.
When the notice arrives, it looks final, not dramatic, not decisive, organized. The heading reads, Procedural Update. Daniel Reyes reads it carefully because experience has taught him that nothing important is announced loudly anymore. The notice explains that the court has reviewed the procedural posture of the case. It states that all interim measures were implemented appropriately, that required opportunities for response were provided, and that the case is now proceeding in accordance with established guidelines. No objections are mentioned. No arguments summarized, just compliance with procedure. Daniel asks his attorney what it means. The attorney exhales and tells him this is what comes after delay. This is where everything becomes formal. The attorney explains that once a case is procedurally aligned, it becomes very difficult to interrupt, not because of law, but because every step has now been documented as proper. The system no longer has to justify itself. Daniel reads further. The notice references timelines, windows that opened and closed, periods during which action could have been taken, each one marked as satisfied. Daniel does not remember seeing most of them. The attorney explains that many procedural opportunities do not require notification. They exist as options, not invitations. If you do not exercise them, they expire quietly. The notice continues. It states that because all requirements have been met, further review will proceed administratively. No hearing is scheduled at this time. Daniel recognizes the phrase, "at this time." He asks whether a hearing can be requested. The attorney explains that hearings are granted when necessary to resolve disputed facts. At this stage, there are no disputed facts on the record. The record has already resolved them. Daniel asks how that happened. The attorney does not answer immediately, then explains that resolution does not always come from a ruling. Sometimes it comes from accumulation. Every email answered, every day waited, every form not challenged. Daniel reads the next section. It confirms that all prior measures remain in effect pending final disposition. The word final appears for the first time. Daniel feels it then. This is not preparation. This is entrenchment. The attorney explains that procedure is designed to create stability. Once stability is achieved, change becomes disruption, and courts avoid disruption whenever possible. Daniel asks if stability means fairness. The attorney does not say yes. Another notice arrives days later. This one confirms that the case has been transferred to administrative processing. Daniel asks what that means. The attorney explains that it means the case no longer requires active judicial attention. Everything that matters has already been decided. Daniel asks when the judge will rule. The attorney explains that the judge already has. Just not in the way Daniel is expecting. Daniel reads through the growing stack of documents. Each one references the last. Each one confirms compliance. Each one narrows his options further. He realizes something disturbing. No one is acting against him anymore. The system is simply continuing. Daniel asks whether there is any way to challenge the procedure itself. The attorney explains that procedure is presumed correct. Challenging it requires proving error, and error requires deviation. Everything here has followed the rules. Daniel asks what happens next. The attorney explains that the case will reach final disposition once administrative review is complete. Daniel asks how long that takes. The attorney shrugs. It depends on volume. Daniel sits with that. Volume. His case is now one of many. Indistinguishable. The record will show that Daniel Reyes was afforded procedural protections. It will show that timelines were observed. It will show that all actions taken were consistent with policy. It will not show how procedure replaced judgment. By the time Daniel understands what by the book really means, the book has already been closed around him. There is no urgency anymore. No tension, no debate, just process. Daniel realizes something important. If the system wanted to stop, it could. The fact that it hasn't is the decision. Nothing remains to be argued, only to be finalized, before the gavel fell.